Registrar Mediation Board Chairman, Madam Marilyn Kimmy.
Family of mine since 2017, and so we've had a long stretch of friendship, and I really appreciate the invitation to speak today to the honourable delegates that you have before you. And so I take the same fashion and adopt the same order of salutations that have been delivered by the speakers that have spoken before you, honourable guests. I have been presented to you as the chairperson of the Africa-Asia Mediation Conference, which was established through a declaration here in Dar es Salaam sometime in 2019 through the push and power and energy of the Bangladesh International Mediation Society through the leadership of Advocate Wasumi. And so I really do have this great privilege to have this relationship with you. It was formulated just after the Singapore Convention, and I heard my former speakers discuss the issue of the Singapore Convention and the importance of it within our regulatory frameworks. Now, for me today, I was asked to speak about the requirements of mediators in light of legal aid. Of course, this is not my forte. I am a civil and commercial mediator, and so therefore my commentaries will be slightly towards trying to pinpoint that thin line that community mediators, which we call in the legal aid arena, we call them community mediators, would need to appreciate from the experiences of private mediators that have either mediated family disputes, workplace disputes, and commercial disputes. Now, I'm slightly crippled because most of the presentations before me were not in English, and so therefore please do forgive me in advance if I am at all repeating what has already been presented to you. And so we understand the mediator acts as a neutral and an impartial third party who assists the parties in reconciling a dispute. Now, in specific laws, country laws, we've not seen a sort of a tied-up connection to legal aid, and we've not seen that because most of jurisdictions, especially common law jurisdictions, have not gone the long way to regulate mediation within their jurisdictions. Now, but if we look at India, for example, which is a great example of common law jurisdictions that have this relationship with England, then you would see in their new 2023 Act, we have mediation being defined in a much wider scope to cover and pick up all these bits and bobs that the usual mediation definition, of course there's no one standard definition, but the usual mediation would not have picked otherwise. And so what the Mediation Act in India says is it's a process where, whether it referred to the expression mediation, pre-litigation mediation, online community mediation, conciliation, or an expression of similar import. And so the words community mediation really carried forward to aid it now further when it's defining community mediation. And in that law, they have a specific, in their law that regulates mediation in the country, have a specific section or a part, I think it's part 10 if I recall correctly, that deals with the community mediator separately from other types of mediators. And it's very important that that line is drawn at a very early stage because community mediators to me play a very, very different role to that of a workplace mediator, to that of a family mediator, and to that of a commercial or civil mediator. And so if we look at the part X or part 10, they then define it, they then provide for provisions that are linking community mediation through the Legal Service Authority Act, and also speak of, through those sections, and I won't go section by section, through those sections we speak of there having been persons that could be concluded in the panel, having a person of standing and integrity who are respectable in the community, for example, any local person whose contribution to the society has been recognized. So that panel is then charged with ensuring that the procedures for community mediations are well adhered to in accordance to the regulations or the law been put out in 2023. Now, mediation is a very powerful dispute resolution process that can empower parties, as we've understood from the presentations before us, transform the relationships and give effect to lasting, harmonious conflict resolution solutions. It also attempts to operate much faster than, of course, the litigation or adjudicative routes of arbitration, for example. And so, with that access to justice, it's very significant and a significant concern in this regard to Bangladesh, such efficiencies of having a well-rounded, regulated mediation framework would be very valuable to Bangladesh and its society at large. So then it comes to what makes a good mediator. That's the question that comes to mind when the question of requirements of mediator comes up. And so we'll also explore as to the role of the mediator in that regard. So unlike an arbitrator, the mediator does not impose a decision on the parties. He does not do that or take any side at all. He will not determine the rights and obligations or the wrongdoings of a particular disputes, but merely the role of a mediator is to play a facilitative role. And so they are facilitating a negotiation, and that's why some refer to mediation as facilitative negotiation or facilitated negotiation, when you involve a third party neutral, as opposed to just a mere negotiation where the parties themselves approach that particular issue in attempts to resolve them without involving a third party. And so the mediator is not a judge, nor an arbiter, as they would say, does not make any decisions for the parties, and does not impose her or his will on the parties. This is one principle that mediators would have to, in their role, keep in mind, the principle of self-determination. And so this is a role that links to the principles of mediation. So it's not only a principle, but I'll take on all of them, but mediation also, we understand, is confidential. And its confidentiality stems out from common law or statutes or the contract itself, contract law. And so mediation is considered to be private, confidential, on two levels, I would say. Firstly, the mediation process must be kept confidential at all times, in that no third party is allowed to be privy to those proceedings. And then secondly, under no circumstance, they would say, in most authorities, should any matters discussed in a particular private mediation or session with the mediator be disclosed to any other party by the mediator without the permission of the parties or in subsequent proceedings. And so now, this also is an ethical and professional code of practice that needs to be observed by mediators. And in light of legal aid, this is something that those mediators or community mediators will need to observe and be able to now stream it into the line of thinking of a community mediator that is resolving community types of disputes of all levels, which, with community disputes, there could be groups of people involved, and that group of people is very hard to manage in terms of now cutting through the principle of confidentiality in a group of people that you're trying to establish or create harmonious relationships between. And so these are the issues that the role of the mediator will have to keep in mind. Now, another issue that I had in mind this morning for you is the issue of the mediator's liability in light of legal aid. And liability has never been discussed at length in most of the rooms that I've walked in, because at most, mediator's liability arises from negligence, breach of contract, or breach of fiduciary duties that are assigned, that are vested on you, often concerning, of course, impartiality, confidentiality, and conflict of interest. Now, if you look at case law, not only in the English jurisdiction, but also in the African common law jurisdiction countries, and I've looked in India as well, where we borrow a lot from, and in the United States, mediators have a duty, yes, but no decision definitively sort of outlines a duty of care for mediators. So instead, the courts, if you look at most of these judgments, the courts would occasionally revoke agreements reached in mediations where the mediator acted or poorly or behaved poorly. And so that's what I have seen in light of that case law. And similarly, for example, in England, there are no cases, and if I'm correct, and you can check this against the statement, where a claim has been made against a mediator for breach of contract, misinterpretation, negligence, or fiduciary duty. I have not come across that particular jurisprudence as of yet in my research on mediators' liability. And so it's a very, very interesting space for mediators that are going to now be conducting within the realms of legal aid to take into account that there is this risk of liability. And yes, we're vested with certain immunities, but we need to tread, especially where mediators wear more than one hat. And that is becoming more common these days through developments of mediation, through hybrid processes. And in spaces of legal aid, community-based disputes, we tend to do this very much, that sort of hat on, hat off, in order for us to be able to guide and facilitate parties through the solutions. And so it's very interesting to learn that liability-wise, no court of law in many common law jury court seats have outlined a duty of care for mediators or a definitive standard of care that I mentioned earlier, to which mediators must adhere. So in short, the courts have failed to describe mediator liability clearly. And so it is something that Bangladesh, through its legal aid efforts, could be able to then ensure that mediators that have been vested with the whip to carry out these functions have knowledge of this particular risk. And so, of course, the risk is not very high, because ideally, as we understand, mediators or mediation parties who are dissatisfied with the quality of mediation services retain that low cost, no cost sort of unilateral option of saying, hey, we don't see this going anywhere, we wish to terminate due to unsatisfactory, we're not finding it to be a satisfactory mediation thus far. So ending the mediation typically prevents further injury to the parties, if it's a poor mediation, that is. So in fact, disputants should be cancelled, and legal aid, they should be cancelled to take steps to mitigate their damages by avoiding injury and continued injury by terminating the mediation, if at all they see that this particular mediation is not going in the right route. And so that is now, by understanding these key principles, which I've just highlighted three: the self-determination, confidentiality, and issues of liability, and the fact that we must be at all times be able to observe our duties as mediators, being impartial, being in fiduciary duties being highly observed as a duty of care, and ensuring that there is no conflict of interest. I then move forward as to why those were important for me to say before informing you of the requirements of the mediator. Now, these really do cut through the requirements. Why? Because without the requirements, then you would not understand the principles that are attached to your law. Because the requirements themselves, for example, in most across jurisdictions, each jurisdictions vary in terms of the requirements of what a mediator, for a mediator. There are some requirements in some jurisdictions where they require specialized training that needs to be demonstrated through active listening, communication skills, verbal cues, non-verbal cues, and the likes, and the fact that they have these techniques for problem solving and other techniques, such as empathy or what we call emotional intelligence, which is something that is being taught more and more to mediators at this time in our time decade. And so the requirement for training is very crucial in mediation. And through that training is where these principles are highlighted to ensure that mediators are working within that global realm that they have created in their role as facilitators to resolve disputes. And so training, most commonly in most countries, and I've heard from presentations today, require about 40-hour training. I think that's a standard that's set in most common law jurisdictions. And programs are skill-based, where you have role plays and performance evaluations, where they put you on the role of a mediator in a particular legal aid related matter, and put you to the test, and should also involve a mentoring element. This is something that I have come to learn from the system that we have in our country, in Tanzania, where we do not have a mentoring element. And that is a really disappointing element of our system, because then you find mediators that have just finalized their 40-hour training, getting into mediation, and they have not had that sort of exposure yet through any mentoring system or through a co-mediating relationship with another mediator to see how mediations are driven. And so then poor training ends with failed mediation or unsuccessful mediation, which then results in the trickle effect to the end users not trusting the process. And so it's very important that we continue to enforce the requirement of a particular training and peg it either to an hourly requirement or to a stricter requirement, which would require maybe a more formalized training that is slightly longer. Now, it's not just any training, as I say. Specifically for legal aid, they would have to then go through community-based trainings for mediators, specifically for community-based kind of disputes, because the community, is sensitive to local culture, realities on the ground, through different areas of the country have different ways of approaching certain issues, and so therefore the sensitivities of those cultures have to be taken into account. And you have to also, at the end of the day, also comply to international standards that have mediation. And so these linkages have to be structured in a way that work for community-based mediators for the particular trainings that I've just spoken about. Now, I think we've all spoken about the specialized skills. These specialized skills are taught within those training curriculums, but more so, I think mediators also need continuing professional development programs, and these should be very much so put at the top of the list of requirements of a mediator, because mediation continues to evolve. We saw in the wake of COVID-19 the involvement through mediation being conducted online, and through those conducts online came different guidelines, came different certain standards one may observe to ensure that the principles, the underlying fundamental principles, are kept at observance by mediators. And so, yes, they continue to develop. This is a field that is continuously developing, and so continuous professional development is also another requirement for mediators. Now, in terms of country-specific requirements, as an international mediator, I've seen a lot of requirements of a different nature. And I'll speak maybe to my experience here in Tanzania, where we have an accreditation system. and the accreditation system requires all mediators who are practicing at a fee. And so because it's at a fee, then you have to be accredited and registered at our Ministry of Legal and Constitutional Affairs. If you're going to practice under a certain legal aid body, and then you are not being a mediator who performs at a fee, then this particular requirement would not fall within your, would not put you in that trap. We've also got court registers or rosters. These, of course, for our country are still yet to be implemented. But if we look at our neighboring country, Kenya, it's working very well, where we have court registers or rosters that require to be adhered to in order for one to be able to be sitting in mediations that are connected to the courts. And so skills, core skills, yes, we spoke, active listening, empathy, strong verbal and non-verbal skills, ability to define and clarify issues. These are requirements on that role as a community mediator as well. And so I'll take it to an end here because I think my minutes are over. But this is really what we as mediators should put forth in terms of the requirements of a mediator. We should not forget that these mediators who are going to take up these mediations will have to have some sort of experience. I think I'm going to repeat this because experience is key. So basic techniques are necessary, but it is crucial for those skills learned through hands-on or at least co-mediator role mentorship programs, so that inexperienced mediators are not put up for the work when they're not ready, having that experience to deal with the challenges of a mediation. And so that's really what I would like to present today. And thank you for the opportunity once again. I look forward to the discussions as we proceed with the other items of the agenda.